So we are back and we are in. We have the possibility now to have some time for discussing these very rich presentations. The only thing I would like to say as an introduction is the following: that by taking together the three presentations, probably with the exception of the presentation by Johan on the Inter-American system of protection of human rights, in which probably the comparison came to a point in which there are more divergences than convergences with the EU supranational judiciary. We are in a situation in which it looks like the supranational judiciary is alike at the same time the federal model and the ECHR. So, isn't it a little bit contradictory or paradoxical at least? Or is this a symptom of, in a way, the peculiarities and the distinctiveness of the supranational judiciary? I leave it deliberately open as an introductory point, and I open the floor to intervention, questions, comment, critiques. Matthias. Sorry, for the sake of registration.
Three interactions, but one by one.
We are recording, that's why
okay.
It is important, sorry.
Thank you. Three interventions for each of them. One, with respect to Lello, yeah, you mentioned it correctly. I think this is important with respect to the supranational judiciary. I think there are two things we have to differentiate. The one thing is the organizational question. And there I would say there is not a big difference between the German federal judiciary and the European one. We have on the state level a judiciary established and formed exclusively on the European level by the European states, on the German level by the Länder, by the regions. And then we have a top. A top, this is the ECJ in Germany, be it the Constitutional Court to a certain degree, the Supreme Courts of the various branches. So organizational, it is already a federalization of the European system. Because I always would say that the national courts, as far as they apply European law, they act as European lawyers, European courts. The next thing is the question of federal conflicts. And this is much more tricky. Because on the one hand, it is very clear that it's up to the ECJ to decide these things according to the treaties. If there is a violation of competencies, it's the ECJ which has to decide it. But then we have the decision of the national courts, specifically the Constitutional Court, and here most specifically the German Constitutional Court, which spoke of the so-called ausbrechende EU-Akte, meaning acts of the European Union which are violating the competencies attributed to the European Union. And here the reasoning of the German court is it is not only a question of European law, but it is at the same time a question of the national law. Why? Because the European law still applies within Germany thanks to the laws of ratification. And these are national laws. And in these laws we say we will allow the application of the European law to this extent. And the interpretation of the German law of ratification is with the exclusive competencies of the German courts, here with the Constitutional Court. So here there is not a federalization, because of course within Germany, Constitutional Court of Bavaria has not the right to decide these questions. This makes a difference. So organizational, I think, fully fledged federal system. With respect to the organization, it's still with respect to the competencies, is a difference. Thank you very much. Yeah, may I? Sorry.
No, very short. Very short, because I am on Matthias. I disagree completely with the first point. Okay, great. Yeah. Because the reason I put forward yesterday, recruitment, training in the European Union are completely different. So we have, while in Germany, recruitment and training are very similar. I think also almost the same. There are some slight variation for what regards independence between the land. There are some variation because in some land you have an advisory committee. But as for recruitment training, you have the same competency. This is not the case of the European Union. As I told you, there are at least 4 types, at least, but you could multiply. So from this point of view, I put forward an order.
Other questions? So, okay, would you like to? I think we can collect all the questions and then leave the panelists the opportunity to reply to the questions raised in their respect. So, Matthias, if you want to complete the other questions. Yeah.
The second point, the second question here, John, I always have difficulties with using the idea of supranational effects of this jurisdiction, because it's already part of international law to a certain degree. Of international law, that if there is such a system, like the inter-American system, and if there are decisions, it's within the treaties what will be the effects of the decisions. And this is, I think, this is all, and I think I have some doubts if we say this is a supranational thing. The supranationality, and this has been mentioned, has something to do specifically with the legislation. With the legislation, primacy is a question of the legislation. The legislation, and here, and this is the main difference, here the primacy is claimed by the European law, whereas the obligation to apply the decisions of the court, of the Inter-American Court, the Costa Rica Court, this depends on each constitution in the states. We can discuss it, of course, but this, I think there is a difference. I think it's very important, if we might go the way in the direction of the supranationality, to mention Article 63, the question of the implementation. And here there is a big difference with the European Court, because the Inter-American Court imposes direct obligations. You have to do this or that. In the Hellman case, they said, you have to build a monument. You have to build a monument for the person who has been killed there. This is unimaginable to a certain degree with the European Court. The European Court is limited to say, we state that there has been a violation, and then it is up to the national organs to react, as a rule. Changing a bit, but as a rule, this is a difference. And therefore, whenever we want to talk about a supranationality, I think we have to go to the question of the implementation. I think in this context would have been interesting to see the role of the margin of appreciation. The margin of appreciation, what does it mean? You know, the interplay between the two systems. In Europe, we have the margin of appreciation. In the Inter-American system, not. What does this mean? You know, I do not have a ready cooked answer, but I would like to hear something about it from you. With respect of the ranking, you said the common law system, then they have a lower ranking. It's the same also in continental Europe, in Italy, or in Germany. You know, the international treaties are on the level of ordinary law, perhaps unfortunately, yeah. And the last question, you mentioned the amnesty cases, and to a certain degree, blaming these different countries. Perhaps I misunderstood. Okay, just stating that there are some cases unwilling to do so. I would just like to mention the background of the Hellman case. In the Hellman case, there have been two referenda by the people, and they decided in favor of amnesty. They said, no, it's finished. We do not want to open the box anymore. And then there was a court in Costa Rica. The court said, no, you have to this is a violation of the principle of the right to life, because the right to life implies the fight against impunidad. And this is, of course, a big question. If an international court composed of 7 judges has the right to go against the whole people, you can say it's now 30 years ago. But I would like to see the answer of this court in the Colombian case, where all depends, you know, the negotiation between the FARC and the government, all will depend on the regulation on amnesty. And they have a very, very difficult regulation there. There is not a full-fledged impunidad, but it is said if a person confesses, I did this crime, then he or she will not be put to prison. And this is still something. And I will see if the court will be able to say, no, this is a violation of the convention. But this is a very specific question. But if I'm asked, sorry, then I have to go to Monica. Yeah, the equality. I'm very, very deeply rooted in the principle of equality. Yeah, I might have a bit exaggerated the importance of the preliminary procedure, because in the end you can also build up a coherent system if there's just one possibility at the end. It will, of course, strengthen the position of a court if it can step within the ongoing proceedings, but I think this is not that important. More important is the question again of implementation. And here you said the court could have been more active, but on the other hand, there is Article 46. The Article 46 said the court, and then the rulings, the internal procedure said it only can state a violation of the convention. That's all. It cannot, for example, eliminate a national law. It cannot quash a decision of a national court. It just can state the German Constitutional Court violated the convention. That's all. And this, of course, makes a difference. This makes a difference. And yeah, if it can eliminate, of course, the integration of the whole system is much stronger. If the European...
The ECJ can also not...
Yeah, this is also a problem. I think this is a problem with the ECJ. Yeah, I think there is still a deficit to this extent. This is not fully integrated. I think it is a possibility. The decisions, do the courts have the obligation? Do they have the obligation to follow the decisions of the European Court? I can say yes and no. Yes, of course, whenever there is a case concerning the Germany, for example. Then not only Germany as a state, but each court has the obligation to implement it. How it does so, this depends on the internal order. There we have difficulties. By the way, less than Italy, because now in Germany, we introduce in all procedural orders the possibility to reopen the cases, which is not the case in Italy, for all I know, but please correct me. So in Italy, it's not, and this is a scandal, I think. But here, and this is a mistake of the court, again, the European Court, it never required the states to introduce the possibility to reopen the cases. And therefore, the national courts always can say, this is a res judicata, I can't do nothing. And they are right. In the French court, the French courts did so. In the German court before, it's also. In Spain, there was a certain difference. So, in general, inter partes, there is an obligation. If they have to accept or recognize the case law in all, this is a different thing. And here I would say they are bound, like an inferior court is bound by the Supreme Court. Is the Tribunale di Firenze bound by the case law of the Corte di Cassazione? Yes and no. In a concrete case, always. In general, they always can challenge the case law of the Supreme Court, of the Corte di Cassazione. It is possible. It's not a violation of the law. And then they will be quashed. So, in general, they will follow. In Germany, this is interesting. We have the Görgülü thing. The Görgülü, everybody says Görgülü, Germany declared, and this is in the constitution, in the decision, Germany, the German Constitutional Court said, if there is a conflict between the constitution and the convention, the constitution will prevail. Yeah, you find this sentence in this decision. But the second part is much more interesting, because it said, all German courts are obliged to take into consideration the whole bunch of the case law of the European Court of Human Rights. And if they do not do so, they violate the equivalent fundamental law of our Constitution. And then the persons can go before the Constitutional Court and say, see, in this case, this court of Firenze or of Munich, they did not take into consideration the case law of Strasbourg, and then the German court quashes this decision and sends it back, and now you write a new decision taking into consideration the case law of Strasbourg. And in this way, and this is interesting here, this is a very interesting point for the
court. So even, being lawyers, the concrete consequences in concrete cases will be very different, so probably it's an indicative that is very different. And very clearly, you were talking about the first McCormick, there is the second McCormick in which pluralism under international law, which is limited pluralism. Okay, if there are different types of pluralism, then I think there are two questions in order to decide which is the best pluralism of, and it's very pluralistic, that there are different pluralism. It gets very pluralistic. But I think there are two transversal questions that are very well illustrated by the three papers. And have to do first, and I think this is the key one, which Miguel was avoiding yesterday. Sorry, he cannot prove that I was wrong. But I think he was avoiding because the question is to what extent this really corresponds to the actual practice. And to the actual practice now, not 10 years ago. If you would ask me if it corresponded to the practice 10 years ago, I would be leaning to say yes. I'm not sure now. And by means of bringing the Inter and the ECHR, one also gets further evidence that pluralism has problems when having to deal with certain socioeconomic realities that seem to render, let's say, the scope within which it can operate problematic. If this is so, then there are range conditions of pluralism. So it's not that on the one hand we have to discuss whether it's a good reconstructive theory of practice, but whether it's a good reconstructive theory of practice depends at the same time not only on the normative capacity and to be a sound normative theory, but also about the kind of socioeconomic structure we are speaking about. So perhaps in certain places it can work, in other places it cannot work, in certain circumstances it works, in others doesn't. Which are the preconditions for constitutional pluralism being viable? And these other examples prove that perhaps it's problematic, and which are the reasons? Could it also be that it would have become problematic in the European Union? And I would only add, we will go to this obviously on the evening, that the growing conflictivity between constitutional courts and the European Court of Justice perhaps is an indicator that the conditions are no longer there for one reason or the other. And does not have to do with the courts, it has to do with the underlying law. And in that regard, I would say that even some of the proposals that pluralists have been making, Matthias, Kuhn, and Miguel, to me sound very monist. And I think to McCormick would sound very monist. Like we should have a single tax, not really democratically, by the way. We should have this as a functional need, blah, blah. All this does not sound to me pluralistic. Sound to me extremely centralistic, which is a different kind of game. And I'm understanding, you have understood by now, if I have to choose a pluralistic option, is the McCormick option. So then the question is that we have 28 final words on the hands of national constitutional courts, or high courts playing the constitutional role. Second question, I think, Weiler had this famous criticism of deliberative democracy on the basis that no doubt that professors like deliberative democracy. This is what they do. They talk, talk, talk. And there is a point, I think, on that. But if this is so, is it not also a question that we can ask whether constitutional pluralism is also something that judges like? Because on the one hand, I was asking just a minute ago about the socio-economic preconditions. The other is what kind of price it has if we accept as a sound theory constitutional pluralism, in the Miguel's rendering, in terms of the power of judges. How much are they empowered? Because on this, allow me for a second to relapse into a Jacobin frame of mind. In order for the law to bind judges, there must be one law. If there are 3 or 4 laws, are we sure that the judges are bound? Or the result of 3 or 4 laws is that we are unleashing the discretion of judges. And at the same time, they can say, oh, we are applying the law. Only it's very complicated, you know, because there are 3 or 4, and we have lots of disagreements. So can there be rule of law if we have 4 rules of law, or 3, or 2? And this, very briefly, brings me back to the question of Schmidt, because the thing that I would simply add, my understanding is that the Schmidt is overrated for the wrong reasons and underrated for the wrong reasons too. So he's underrated all the time, or overrated all the time, but for the wrong reasons. The book on constitutional theory, there is one side that, that Professor Bifulco was putting forward. Then there is also this question of judicialization and his understanding of the US Supreme Court, and which is. And there are several Schmidts, and very obviously the Schmidt of the strong state and the healthy economy of 32 von Papen kind of version was saying things about economy and this kind of stuff. But the underlying problem that we could also pose to constitutional pluralists in that regard is it's not only about judicialization, but it's about false pluralism in a way. Because what is the concrete result of the model of constitutional pluralism a la Miguel, so to say? It comes hand in hand with a very strong understanding of economic freedoms, I must say. But a strong understanding of economic freedoms is not pluralistic at all. It's terribly abrasive in terms of national competencies. So it's centralization with a market face, so to say. But it keeps on being centralization. It keeps on imposing one single model. I mean, Colin Crouch now has a wonderful book, The Knowledge Corruptors, is the rise of financial knowledge as the only knowledge around. And I think it's very much related to this kind of process. But if this is so, then the question is that certain models of pluralism then, and we can rely on Schmidt partially on that, do end up in imposing, you know, under technique, under scientific knowledge, in economic, and this kind of stuff, they end up imposing, under the cloak of pluralism, a very strong monism. So then perhaps the proposals to deal with the crisis are not surprising, are only in continuity. Only the underlying monism becomes explicit kind of monism. And it's a pity he's not here, because then I will be proven wrong immediately.
Are there other questions from the public? Because I would like to make 2 points. One is refer to the paper of Raffaele Bifulco, and the other one talks to both Monica and Joan. So, as I understood Raffaele Bifulco presentation, I think one of the main points of the presentation was that the current situation of the European Union judiciary is alike the situation you may find in the starting period of a federation. And in addition of which has a judicial organization which resembles that of a federal unitary state, but at the margin having a situation in which we are still in a confederal institutional setting. So I think that what could be brought into the paper is the element of differentiation, which is one of the main drive of the current European integration process, and that probably could, undermine the quite coherent setting we are having in the elements, or among the many elements. I think the two most important are one, which is the lack of the preliminary reference procedure, which I think is still, from a procedural point of view at least, a very important key element missing both in the ECHR and in the inter-American system. But most of all, I think that there is a divergence with, Joan didn't develop much, but I think is the critical divergence, the fact that the European Union and the supranational judiciary at the service of the European Union is a governmental project. Governmental in the sense that it develops policies. It is about policy making. Whereas both the European Convention on Human Rights and Inter-American system are not about making policies. It's about constraining policy. So if you take this element into the picture, you end up with a situation in which all those who are similarities may apply, and I would say might apply, overemphasize my doubts in this regard, with the limited field of European Union law, which has to do with fundamental rights. But please consider that the bulk of EU litigation is not about fundamental rights. It has to do with the application of EIT directives. It has to do with the application of bulk of legislation which has nothing to do, or which has very few elements connected with human rights. And so, if we take seriously this element, which is not recent, which goes back to the origin in a very perceptive comment celebrating the anniversary of Van Gendenlos, Joseph Weiler said that one of the crucial element of Van Gendenlos, that it legitimizes a system of governance. It is a proxy for governance. It allows the emergence of a system in which you are not imposing very sparse and diluted principles on member states. You are imposing policies, elements. If we want to use the distinction, it's about more enforcing rules than principles. So I think this element creates a discrepancy, a divergence that we really need into account to when we arrive at comparing the ECHR or the inter-American process with the system of adjudication of the European Union. Basically, the supranational judiciary is to a large extent in a different business than the ECHR judiciary or the inter-American judiciary. Yeah, of course.
Thank you. Just a comment on your comment and a comment on Solanas and Monica. I think your remark has been very important, because I think when you compare the position of a judge in the European Union and the position of a judge in the European Convention on Rights or Inter-American Rights, it's radically different. Because in the case of the European judge is adjudicating between the European Commission and national states, normally. So in any case, no, very often. And so in any case, he will be supported by one of the winners, and the winner is a very powerful actor, the Commission of National States. When you are in the European Convention on Human Rights or Inter-American, the judge is adjudicating between a state and a citizen, very often a weak citizen. And so it is very risky business from the, I think this is a point has to be taken. Then I have a question for you from the point of view of an ignorant guy here. What do you mean by constitutional pluralism? Are you talking about legal doctrines, different interpretation of constitutionalism, or you are thinking also to doctrine which combines legal and non-legal arguments, financial, economics? This is something I was puzzled. I didn't know, just because I am, a foreigner here. So I wanted to know. This is very interesting. Very interesting, I think, the point raised by Augustine. But actually, it's changing all the, it can influence the discussion. Thank you very much.
Are there other questions, or can we leave the floor to the speakers? And I would suggest we do it on a reverse order, or if you are okay with that. Or okay, we start with Monica.
Okay, thank you so much for all the comments and questions, and they require a bit more reflection, but I will just pick up on a few. First, one that was not addressed to me. So on the decentralization, and that the German system is the same, or that the EU system is the same as the German system with decentralized and then on top a centralized system. Well, the difference is that in Germany, Landesgerichte are German Gerichte, which is not the case for national courts in the EU system. We don't have a unitary system, right? So that is the fundamental difference, I would say, between both. Organization, sure. Yeah, but still, I mean, there's still German courts in the sense that they all belong to the same legal order, which is the important and fundamental difference for the EU. Well, okay, so that's one, and maybe this is one that's more for you. Okay, then I should not exaggerate the importance of the preliminary reference procedure, because there is other ways of achieving unity in a legal system, uniform interpretation in a legal system, of course. I mean, the EU, it could have been different, and those were the options when the system was drafted, right? Do we need a European Cour de Cassation, or do we go for the preliminary reference procedure? It could have been both. Both could have worked. We chose and in the other case, could the court have had the opportunity also to introduce direct effect and primacy? Yes, it could have been, except that is a system that does not exist. And the preliminary reference procedure, I do think, still is hugely important and has been hugely important to do this, and because it gives much more opportunities to really interfere and to direct national courts. So I don't think that it is possible to overstate the importance of the preliminary reference procedure. On Article 46, I think that I don't agree with your reading of Article 46, both in inter partes cases and in inter partes and beyond the individual case. I think that for the defendant state, Article 46 says you have to do whatever it takes to stop the infringement. Does that impose an obligation under ECHR law on the national courts of that state to comply with the judgment? I would say no. If they would not do so, they will contribute to a new infringement, and that opens up the possibility of new actions being brought. But I don't think that there is... No, in the given case, I understand, but I don't think that there is an ECHR obligation to do so. Obviously, if they don't, that is a new violation. They contribute to a new violation, but I don't think that there is an ECHR obligation. And of course, it is wise for the state to make sure that its courts comply with the judgment, but it's for the state to do so, and that is what Germany has done so. And this is the point that I was trying to make. It's the different approach between the ECHR system and the EU system. In the ECHR system, the contracting parties have agreed that there should be the possibility to reopen cases, but it goes via the governments, the contracting parties. It's not the Strasbourg court that intervenes and that imposes obligations on the state. So I think that is different, and the same goes for the Gürgelü case. It's German law. So it's the German Bundesverfassungsgericht introducing that obligation for German courts, but it's not the Strasbourg court imposing that obligation. So that is, I think, is fundamentally different between the two. And the German Constitutional Court, in doing so, contributes to making the ECHR effective. But is it acting under an ECHR obligation? I don't think so. It is cooperating. It's very cooperative, but I don't think it's an ECHR obligation. And then constitutional pluralism. I think, are we under time pressure? Can I say a few words on that? Okay, so constitutional pluralism. I just want to say a few things about that. So constitutional pluralism, the whole theory, and the problem indeed is that there are many different conceptions. I mean, Jan has edited or co-edited a volume on that. There's many different theories, many different conceptions, and very often we are talking past each other. So, so the whole thinking, and just to, because I think it's important also in this context, I think the puzzle is this. The puzzle is the EU is not, and we come back to that, it's not one single legal order. It's a composite of legal systems, right? And the one system, it's coexisting legal orders. And in order to decide how the parts of the legal systems relate to each other, there are different rules of conflict. And the difficulty is that the national rules of conflict, of what do you do in the case of a conflict between EU law and national law, do not coincide with the European rules of conflict. And the problem is that we do not have one rule of conflict to solve the conflict between the rules of conflict, right? So that's the starting point. It's plurality of rules of conflict between conflicting or coexisting legal orders. That's a fact. It's a fact, and I would say that is plurality of legal systems and no single rule to solve the problem. And that is the difference, again, between the EU and a federal legal system, right? In a federal legal order, you do have agreement on the rule of conflict. Okay, and then the next question is, how do you deal with that? How do you deal with that situation in case where there seems to be conflicting opinions? And then nice people, such as Miguel, have come up with this theory of constitutional pluralism, meaning that it's more an attitude. It's not more than that. It's an attitude that when deciding from within your own legal order, but you have to realize that you are participating also in a broader, or that there are also parts of the whole system, you have to take account of each other's position. So I would say it's not more than an attitude for courts participate, either the European or the national courts. Now the second part was, or the normative claim, as Miguel said, of constitutional pluralism is that it is a good thing to leave open the question of ultimate authority. So we have these competing rules of conflict, and that is a good thing. We should leave it that way. I'm not so sure about that. I don't think that, and that goes to what Agustin was saying. What does it mean if you have different rules of law applying in the same case and you don't know which one takes? That is the end of law. I mean, one of the most important functions of law is order and structure. And it comes in the place of politics and power, right? And then if you bring in, you never know which one is going to apply in a given case. That is not the best situation for a legal system to be in. So I would say that, no, it's not a good thing to leave open the question. So where does that leave me? What is my position on that? I think that if we participate in a system like the EU, in fact, the principle should be that you accept that if you participate in that system, that you accept that you cannot unilaterally, at your choice, or because your constitution says so, or because you have a preference, deviate from that system. So I would say that the norm, the principle should be primacy of EU law. But that's not the end of the story. Because does that, I'm ending now, that's my final, okay.
Principle of EU law?
No, I think that, I think that national, so that the member states or their courts should accept EU primacy. No, that's my final. Should that acceptance be unconditional? As a matter of principle, yes. Because it cannot be otherwise, because then you reopen the uncertainty and then you end the rule of law. But does it mean that they have to, that there cannot be instances of non-compliance? And there I would say, no, of course not. There must be instances, because the ECJ can be wrong, the EU can be wrong, and is wrong in many times. So I would say, of course, there must be cases of national resistance. There must be cases of national resistance, non-compliance, and a refusal to allegiance to the EU in order to push the EU to, or convince the EU to do other things, but then you must make a reference for preliminary ruling, etc. Are you then infringing EU law? Of course you are infringing EU law. Is it acceptable? No, in principle it's not. But in fact, this is in the same situation as where lower courts deviate from standing case law of a higher court. Are they infringing the law? Yes, they are infringing the law, but for the better. So I think that would be my simple take on constitutional pluralism. Okay, sorry for taking up time.
Thank you. I think that I am not going to address the pluralism issues because you are much better than me. But I am going to answer Matthias' questions and Marco Dani as well, one question. In relation to your questions, well, you said that the fact of the judgments is the fact established in the treaties, but I am not quite sure about that, no, in that sense, because I tried to say that the Inter-American Court of Human Rights is changing the meaning of the treaty, and is changing the meaning or the effects of the judgments that, in theory, in the treaty, the judgments have. No, it's a judicial development. It's like the primacy and direct effect. It was not clear at the beginning of the European Union if really we have these principles or not. Maybe we have now textual basis for this, no, with the Lisbon Treaty, but at the beginning, no. It seems that the Inter-American Court of Human Rights is doing this movement in that sense, and maybe it's clear in the treaty. It was clear in the treaty one kind of effects of these judgments, but now it's not quite sure. This is what I call, it's the supranational aspiration of the Inter-American Court of Human Rights. No? Then the treaty is the treaty, but then you have case law and finally the practice, no? In the field, in that sense. No? And it seems that there are some contradictions between the treaty and the national practice and the Inter-American Court practice as well. No? Then you have as well the Article 63, that allows the Inter-American Court to impose obligations, and this is quite different from the European Convention of Human Rights. I quite also disagree with that because I think that at the end, the European Court of Human Rights has imposing more obligations, or in all the history of the European Court of Human Rights, it has more active, in that sense, imposing obligations, and I think that Monica Claes said very well, especially with the pilot judgments, in that sense, no? That the Inter-American Court of Human Rights. But still, again, this is a treaty, in that sense. The Article 63 is a treaty article, but then the practice, what is going on in the practice, maybe the Inter-American Court of Human Rights can impose direct obligations, but these direct obligations are going to be followed by the national states, and there are a lot of examples that no. And in that case, the European Convention on Human Rights Systems seems more successful than the Inter-American Court of Human Rights. The margin of appreciation, you said, no? I said that there are now calls for applying the margin of appreciation in the Inter-American level. The justification is that now the national legal systems, or if you want to say the states, no, or the social, political, social context of the states are much better now than before. In that sense, this is quite clear in the history of Latin America that now we have a little bit more stable democracies than we had before. And in that sense, also the Inter-American Court of Human Rights, if you speak as well with the judges, they said, well, maybe before the margin of appreciation was not possible in that sense because we were dealing with very difficult dictatorships and very difficult regimes in that sense, and we cannot allow some deference to these regimes. But now maybe the situation has improved, and then we can trust more the national level, we can trust more the national judiciaries especially, and for the reason then maybe the margin of appreciation is a good doctrine to apply nowadays, no? Because the situation has changed. But you can challenge as well this, because I don't know exactly this, there are a lot of states that now has problems, no? And you know very well these problems, which states are problematic as well. Then this assumption that now the margin of appreciation, we we can apply because we are in a better situation. Maybe not. It's completely true. But this is true that the situation has improved. This is really a thing in that sense. Also, the Inter-American Court of Human Rights judgments, the scope, it's different now. It is in another phase that is dealing with more specific problems of the system, not like before that were more systematic and very more profound and problematic and dangerous things. No? Amnesty cases, no, that you said. Well, I think that the Inter-American Court of Human Rights has said very clearly that this is a red line, the case of the amnesty and how it interprets the obligations of the states in relation to the amnesty. I think that you're right in the case of Uruguay, that there were 2 referendums, but if the Inter-American Court of Human Rights takes seriously the contra-majoritarian point of view of human rights, it doesn't matter that there are 2 referendums, 3, 4, or 5 referendums in that sense, no? But we can discuss here always the democratic objection about constitutional judicial review, and in that as well International Human Rights Court dealing with human rights as a contra-majoritarian doctrine. No, but I think that the Inter-American Court is so strong here because this is one of the most sensitive in all the history of the court that has tackled, no, in that sense. And of course, that there is a change. Well, in the case of Colombia, especially that you said, maybe there are a lot of people that is saying that here the margin of appreciation, maybe it's possible a good solution. It has. There are a lot of Colombian scholars that are saying that in relation with the remedies, in relation with terrorism, there are some cases that arrive at the Inter-American Court in relation with the FARC and so on problem in Colombia, and that the Inter-American Court had to take in the past some margin of appreciation in relation with the remedies to that national Colombian courts are doing. No? And in that sense, if the future agreement is come, then it is a good position that for the first time, no, the Inter-American Court of Human Rights is going to be here because this is so important. We achieved the peace in that sense. I am not going to deal with that, and I am going to take a distance for that, no, and I am going to accept that. No, maybe this is the first moment that can the court, in relation to that, to take this margin of appreciation doctrine. But we don't. I think that this red line, the Inter-American Court of Human Rights, maybe cannot be trespassed even in this case. No. And in relation with, I think that in relation with Marco Dani's point, I think that I agree with you that one of the most important differences between the 2 systems is this governmental approach. But it is also true that I think that this is completely applicable to the European Convention Human Rights System, but I am not quite sure about the Inter-American system, because you have also the Commission, that is a very political actor in that sense. The thing is that how you decide policies, no? Because when the Inter-American Court of Human Rights or the Commission profoundly says that the way that you are dealing in Venezuela with the judiciary, this is not taking a policy, in that sense, changing all the system of the judiciary in Venezuela, for instance, and says the Venezuela decision is clearly to decide one kind of judges, and we want one kind of judges. But then you are saying, no, this is completely wrong. You need another kind of judicial system, no? But in that sense, maybe not. Maybe it's all contra policies, as you said, and it's not really a policy. But the thing is that it's not strictly a judicial system, the Inter-American Human Rights system in that sense. It is integrated in the Association of American States, no? In the Organization of American States. You have the Commission, that the reports are very political, and they have seen these reports in the system as political as well, especially for the states actors, no? In that sense. And maybe then in that sense it's quite different. But I agree in relation to specifically the task of the court, the Inter-American Court, that it cannot be categorized as taking policies, and it is a contra-majoritarian, applying human rights system. No? Thank you.
Thank you.
Yes, I will try to answer in a transversal way. I will begin with the question posed by Matthias. in difference with Monica, I think that there are strong similarities between federal systems and European Union from the organizational point of view. So Germany can be a useful tool to understand how European Union function. The objection of Monica does not convince me at the end, because it's true, federal systems are unitary systems. So state courts also in Germany, let's think not to Germany, let's think to USA. State courts are state courts, not federal courts. So from this point of view, I think the federal idea can be useful for us. Matthias said from the conflict point of view, from the conflict perspective, there are differences. I agree also with this point. Here is the main point which I tried to emphasize is the conflict. In European Union, the conflict is open. That's why I spoke about constitutional pluralism. And I beg pardon to Miguel Maduro yesterday. That was I didn't understand if he was angry with me or not. But I think the conflict is in the European Union open. We have, Monica said, we have no precise way to resolve conflicts, no single rules. This is the idea of constitutional pluralism at the end. It's the common denominator between Walker, McCormick, Poyares, Maduro. The problem is, can we say we are satisfied with this situation, with this asset? And here I come to the question posed by Augustine. Sure, we have different types of pluralism. Constitutional pluralism is the last kind of pluralism. If we start with Gierke or with Lasky or with Germany, Ernst Fraenkel, and so on. Augustine said, to what extent does pluralism correspond to the actual practice, and maybe constitutional pluralism is what judges like. I agree with you. I think it's really a descriptive theory, a theory that tells us how European Union function until now, I think. The last question. What about, what if the courts say no, Monica? You say, I think that if we are part of the European Union, we have to accept. I agree with you, but what if at a precise moment a court will say no, I don't accept? Here we come back to the sovereignty question. Call it competence, call it unity problem. The problem remains. What if? And here I found very useful reflections of Carl Schmitt. Here there is a decision about a fundamental question, a decision that in the European Union has not been taken until now. And so the eternal question of decision, who can take this kind of decision? The judges, the European Court, the ECJ, the European Parliament, the Commission, the Council. I have doubt about this kind of answers. I know that constitutionalism gave us one answer: people can take this decision. Of course, one people means the end of our world. A world composed, as Monica said, by constitutional pluralism. It has distinct constitutional sides. Do we have other solutions, Marco? I don't know. The problem is, are we able to think a new federal organization? I really don't have the answer, and I stop here. Thank you.
Okay. Other comments? If there are not, I think we can close the session, and we go to lunch, which should be ready at 1. And we could start in the afternoon, the last session of the conference at 2:30. Thank you.